everyone. Good afternoon. I am Professor Caterina Semedeferi. I am the Vice Chair for Undergraduate Education in the Department of Anthropology, and I would like to welcome you once again in this yearly event. We are going to go over our honors presentations today, and then a short award ceremony. So I would like to draw your attention to the fact that we are being videotaped, so please be mindful of any noise, turn off your phones. If you need to leave the room, please do so quietly. You can come in and out. I know everybody's very busy. We have three speakers today, Andre Ferguson, Mona Abud, and Isabel Villasana. And I'm very much looking forward to their presentations. They worked very hard throughout the year to present to you their work. So without any further delay, please join me to welcome them. And I would like to first invite Andre to come up here and we can get started.
Alrighty. Okay. Hi, my name is Andriana Ferguson, and today I will be talking about how the family has shaped the stigma of mental illness in Japan. Now, there's a lot of moving parts to this question. Oh, technical difficulties already. Katerina.
No worries.
Sorry about this, folks.
That's all. Yes.
Okay.
Yep.
Yes, sorry about that, everyone.
Oh, no, actually this sec.
Okay.
Let's try again.
Unfortunately, I didn't prepare any stand-up jokes in case this happened.
You can try now.
I hope it's not frozen. Oh, there we go.
Yes, okay.
All right. So how does the family contribute to the stigma of mental illness in Japan? There's a lot of moving parts to this question. So let's start with why this subject in why this area. The stigma of mental health and mental illness is a global health problem, with activists and people living with mental illness often citing it as a barrier to treatment and a contributing factor in a lowered overall quality of life, especially for people with schizophrenia, depression, and anxiety. But usually when we look at how stigma forms in our cultures, we focus on a European or North American society. So I wanted to look at Japan to understand how stigma might have formed in a non-Western society. And I found that the family had a very important role to play in this, but was often in the background of the literature. As anthropologists, we do love to focus on flashier concepts like the economy or religion. Junko Kitanaka, in her book on depression in Japan, found that the very idea of mental illness, kiutsu, became tied with the economy in the Edo era. And religious healing is so often a form of study in anthropology, not only for mental illness, but illness in general, that people feel that it is a romanticization of mental illness on the part of anthropologists. But the family has been very instrumental in shaping the stigma of mental illness, and how does it do so? I'd argue that it's the culture as a moral systems model at work. In this model, all societies have a social role that matters the most to them. And in order to have full personhood in that society, one must interact with, uphold, and protect this moral value. If a group of people is presented as a threat to this society's values, they are rejected by the society, either intentionally or unintentionally. And this is what creates stigma. This stigma allows for the dehumanization of these groups, and it makes it easier for them to be stripped of their human rights. So in this model, the family is the social value that matters most, and the mentally ill are rejected from society because they are seen as a threat to this value. And I don't think anything quite exemplifies this like home confinement. Home confinement is the practice of keeping mentally ill people in wooden cages constructed in or outside the home. This originally started as a way of preserving the family's social standing. If a mentally ill person were to act out in a way that was seen as unacceptable, it wasn't seen as their fault, but the fault of their family members for not properly controlling and containing them. So the family, in order to preserve their social standing, began keeping mentally ill people in these cages. This was originally a form of informal social control. It wasn't national, and it varied to different degrees and intensities in different regions of Japan. But in 1900, it became the official national method of handling mentally ill people with the passage of the Home Confined Care Act. And this led to not only social repercussions, but legal repercussions for families that didn't practice home confinement. And some of you might be thinking, well, maybe this was for the best. The severely mentally ill might not have been able to care for themselves or interact in society at all. This might be giving them the care that they need. But home confinement was no such form of care. Dr. Tore Shuzo was one of the first people to publish a report on the details of home confinement in 1919. And he found that the majority of home confined people were being kept in unhygienic and unhealthy conditions, with family members often unable to provide the necessary support. In his report, he details home confinement in scenes of disrepair and disgust, with the strong scent of excrement and urine, and in cages where women were kept unclean to menstruation. Tatami mats, which people were supposed to sleep on, had often rotted through or molded over, and there was no way to prevent a mentally ill person from harming themselves in any way. So they weren't really receiving any proper form of care, and most families had to work long hours in the fields or other jobs in order just to stay afloat. And the cleaning and care of a mentally ill person sometimes required the efforts of an entire family and neighbors, so they were unable to provide any form of long-term support. So here we see that this desire to protect the family has resulted in the removal of mentally ill from the society, and this has resulted in a dehumanizing situation for many of them. But this model and the removal of mentally ill people goes beyond just home confinement. In the 1940s, Japan was making a lot of headway in understanding the biological and genetic components of mental illness, but this interacted with preconceived notions of mentally ill people in unfortunate ways. Suddenly, mental illness like depression and anxiety was seen as biological, a fixed genetic part of a person that couldn't be cured, but could be passed on to one's children and the bloodline that they married into. This became a great area of concern for Japanese people because the idea that mentally ill people could marry into your family and produce their children with tainted genetics, they felt would lead to the decimation of Japanese civilization. Because to corrupt the family, the very social unit of Japanese society, would lead to the tainting of Japanese people as a whole. And so the Japanese government and some psychiatrists adopted a eugenics program in order to maintain the purity of the Japanese race. This resulted in many disabled people and many mentally ill people being forcibly sterilized. But home confinement and eugenics can still be felt in Japanese culture to this day. This is a picture of protesters against the Japanese government demanding justice for people who were forcibly sterilized all those years ago. Although eugenics is no longer practiced in Japan, when mental illness is understood as being genetic or biological in nature, people responded that they felt the mentally ill were untrustworthy, unpredictable, and dangerous at a much higher rate than understanding it as being the cause of social issues. And home confinement has been illegal in Japan since the 1950s, but in many ways, mass institutionalization has taken its place. Japan has some of the longest rates of stay in a psychiatric facility in the world, with the average rate of stay being 292 days, or just under a year. For a comparison, the average rate of stay in a psychiatric facility in the US is about 2 weeks. Now, you might also be thinking, but this is good. They're finally being seen by real doctors, getting long-term care. But once again, institutionalization has adopted some of the unfortunate practices of home confinement. Many mentally ill people in the 70s and early 80s were found in conditions where they were shoved into small rooms, tied down to beds, not often interacting with any doctors at all, and given drugs to remain docile. In at least one hospital, in a 3-year period, over 222 patients were found to have died while in the care of the Utsunomiya Hospital. At least 3 of these were the result of murders by unlicensed nursing staff. So we still see that mentally ill people are being rejected from society and put in institutionalization. In the 70s, it could even be done against their will and consent. And in many ways, being rejected from social processes like marriage is still a real factor and concern as well. So what has the Japanese government done to try and correct the situation? In the 1980s, Japan adopted a more human rights-oriented approach to psychiatry and to mental illness, often launching anti-stigma campaigns to fight it within the communities. However, many of these campaigns were ineffective. One such campaign is the renaming of schizophrenia, with the idea that changing the name of the disease would result in younger people having a less stigmatized view of this illness. And this worked in the short term. Many young people reported that they felt schizophrenia under its new name, which roughly translates as mind integration disease, was less harmful and less scary. But in the long term, parents who remembered the old name would pass down their stigma of this new term to their children. So why is this campaign unsuccessful? I'd argue it's because we mostly understood stigma as an end result, the discrimination that people faced, the final and only form of stigma. However, they didn't understand the way in which stigma perpetuates itself and exists within cultures, and the cultural values that we preserve by the removal and stigmatization of mentally ill people. And in order to fully dismantle stigma, we have to understand what perpetuates it. And I think the family has contributed to this perpetuation of stigma through this desire to protect it. However, the culture as moral systems theory can apply to more than just the family. Stepping back from Japan and the family, we can see that the culture as a moral systems theory mainly exists as a way to preserve powers and hierarchy structures in the society at the time. It's no accident that both eugenics and home confinement were legitimized by the Japanese government. And people didn't preserve the family randomly because they loved their parents so much, but because the family represented a microcosm of Japanese society that legitimized other forms of power structures. So with this moral systems theory, we see we can apply this to many cultures around the world and the various systems that we have to preserve at the cost of other people. So before I go, I'd like to ask a question. How does this culture as the moral systems theory exist in our society, and how do we feel it every day? When are we being told that in order to be real citizens or true Americans, we have to reject some groups of people, and we have to remove them from our society somehow? Who are we protecting when we do this, and who really has the power to destroy who in that situation? I hope that I've answered some questions for you and raised some new questions for the future. I'd like to thank my friends, professors, cohort, and everyone who's helped and supported me with this year-long project. I couldn't have done it without any of you. And thank you all for listening and being a wonderful audience. All right, so we have a few minutes for questions. Yes?
Yes, that was a great talk. So the stereotype about Japanese society is that it's very homogeneous and that it really sort of tries to maintain that homogeneity, for example, by limiting immigration from outside and so on. Have you thought about sort of the stigmatization of mental illness with regard to that sort of that larger issue of sort of the social pressures for homogeneity?
Yeah, so homogeneity in Japan is not honestly what you would think. There's a lot of smaller social groups and indigenous societies within Japan that face internal pressure and what was termed in one book internal colonization. The Ainu people of northern Japan are one such example, and in many ways, psychiatry was used to kind of silence a lot of these people, and a lot of acting out against the government's will was kind of used to legitimize removing many people who wanted to preserve a traditional Ainu way of life or a Korean way of life. Homogeneity in Japan is a lot more complicated than I think a lot of people in the West think, and there are a lot of social groups within Japan that don't identify as Japanese or face a different kind of social pressure. And yeah, there has been a history of psychiatry being used as a legitimizing factor for silencing these groups. Yeah, thank you. Mm-hmm.
I don't know if you looked at current psychiatric practices in Japan, but in your research, have you come across any type of Western influence that has made its way to the country in more recent years?
Oh yeah, so Western influence in psychiatry in Japan started in like the Meiji era, so like the 1800s. And a lot of the medicine that they adopted was from a European model. So the eugenics program that they adopted was directly influenced by Germany at the time. And a lot of right now American psychiatry is influencing Japan. They use the DSM-5 classification for various mental illnesses there. There has been a bit of a disconnect at a time when Europe and America was pushing more for deinstitutionalization. Japan was starting to crack down on it more. But I think the push for deinstitutionalization from other countries has started the trend in Japan, trying to create communities that can care for each other, and a lot of activists are trying to kind of rectify the situation where people are removed from their communities and people don't have a voice about the mentally ill in their own communities. So I think for both negative and positive, there has been Western influence in Japanese psychiatry, and it's a long, sordid history, so yeah. All right, anyone? Yeah?
Do you think like the economic benefits that these kind of institutions receive is kind of the pushing power for why they're still being government controlled?
Yeah, so economics is actually one of the other things I looked at in my thesis, and Japanese psychiatric hospitals aren't allowed to turn a profit through this kind of institutionalization. But it became super cheap to build a psychiatric hospital, and you didn't have to prove that you were a psychiatrist or that you could hire people who were medically trained in that area. And so it became kind of really profitable to build for like the owners to basically have like their own careers set up for life by creating these hospitals. There's also like good intentioned factors, like mental health care is almost completely covered in Japanese health insurance through a universal healthcare system, which had some positive effects of, more people have access to medication that they need. But there was a lot of the push towards mass institutionalization was because it was cheaper to just put someone in a hospital than to live with them and deal with things in a home therapy center. So there is definitely a strong economic element to that. Profit is not necessarily like the main motive for the hospitals themselves, but there's like a really complicated dynamic of it being cheaper to build. People could just work there without having to really have high credentials, which is not the case for other hospitals. And in the 80s, there was this whole psychiatric hospital boom that was very, yeah. So yeah, that's definitely a factor. Okay, thank you all so much. Oh, there it is. Oh. Okay.
All right, hi everyone. Thank you for being here today. My name is Mona Abood, and I'm going to be giving you a presentation on my thesis topic, which was racial disparities in plea bargaining. So first, I thought it would be, oh no, same issue. Sorry. It's moving here, but it's not moving there. Sorry.
Let's try this again.
Okay, there we go. Thank you. Sorry about that. Okay, so like I said, my topic is in racial disparities in plea bargaining, so I thought it would be first fair to tell you what plea bargaining is. So here's a definition, but I'll kind of streamline this for you. Plea bargaining is an agreement between a defendant and a prosecutor in a criminal case where a defendant is agreeing to plead guilty to a charge or number of charges in exchange from some concessions from a prosecutor. Those concessions are usually a reduction in the punishment, some punishment below the maximum sentence for that crime they're agreeing to. And while we see trials dramatized in our media and TV, the fact of the matter is plea bargains resolve 95% of our criminal cases in this country. Less than 5% are resolved by by trials. So now that we know what plea bargains are generally, there's different types of them we won't get into today. But I thought it'd be fair to tell you where they happen in the criminal process. So first we have an arrest, that's pretty straightforward. Then people are held for a court appearance. They may be offered money bail or let go on their own recognizance, and we could identify racial disparities there. We also won't talk about that today. They're allowed to have a phone call and contact counsel. Then they would appear at their first court appearance, and that's where the prosecutor and the defendant counsel, be it a public defender or private attorney, would get together and negotiate this plea bargain. So this is all considered the pre-trial status, which you'll hear me refer to throughout the presentation. So at this point, they can agree to the plea bargain, or they can disagree. But if they agree, that's basically the end of the case. They would enter the plea at the next court hearing and receive their sentence to go on to serve it. If they refuse, that's when you would go to a trial, go in front of a jury of your peers, and that's how that case would be solved. So plea bargaining happens again in this pre-trial phase. There are different ways that this can go down, but this is basically the general idea. So now that we know what it is, that it happens 95% of the time, let's think about what the racial disparities are in our criminal justice system today. And we usually think of this statistic, the likelihood of imprisonment, the likelihood based on your race and your gender of seeing the inside of a prison cell at some point in your life. And as we see for Black men, 1 in 3 are likely to see the inside of a jail cell in their lifetime. Given that 95% of cases are solved by plea bargaining, we could intuitively make the connection that there's racial disparities there. But to drive this point home further, we could also look at racial disparities in sentencing. And this is a good statistic to look at because a plea bargain is essentially agreeing to a certain sentence, right? So we see that since 2007, the U.S. Sentencing Commission says that 19% longer sentences are served by Black men, even when controlling for things like crime, criminal history, and level of education. So then the driving question behind my thesis is how does plea bargaining affect, or better yet, infect this process, right? Plea bargaining is regarded as a good thing by attorneys. People like it. I'm also not saying that the people involved are doing this from a racist standpoint. They're good people, they're educated people, they know these statistics. So how does this happen? So first I looked at it from a top-down approach, and this is looking at the systemic or institutional processes that allow for certain discourse between attorneys to reach these disparities. There's tons to identify throughout the history of America. We can look at things from slavery to the 13th Amendment and so on. But when we're looking at plea bargaining, there's some that I'd like to point out today. First is the effectiveness of resources. This is basically the idea that the court system here is overwhelmed. Millions of people are getting arrested each year, and we cannot put a person in front of a trial, or we cannot put every single person in front of trial. A plea bargain is a way to streamline this process. It's a way to use our resources in a more cost-effective manner. The effectiveness of counsel, specifically a defendant's counsel, whether or not it's a public defender, or a private defense attorney, also can lead to disparities. Think about it this way. A public defender is also tied up in this resource game where they have a ton of cases to look at. They don't necessarily have the private investigation teams that a private defense attorney would have, nor do they have the large hour the large pay scale that a private defense attorney has as well. So there's less incentive to further negotiate these cases. Another thing that's really important we'll talk about in just a minute is prosecutorial and judicial discretion. It's also really important to drive home the point that race is always in the background here. While our laws in this country have removed us from being allowed to say doing anything because of a certain race, there's ways around this issue. And these systemic and discursive processes allow for us to get around this. And then there's this idea of the phantom jury that I'm going to go over really quick here. So we call it a phantom jury, and I have to thank Haviland for this term because it just works out perfectly. Because a plea bargain is avoiding seeing a jury, right? But then during the negotiation process, it's all about what a jury would likely find you at a trial should you go to one. So we have to look at the racial disparities in juries to understand how this kind of all goes down. First, we know that juries underrepresent people of color, and defendants of color are the norm. Studies also point out that all white or mostly white juries are more punitive towards defendants of color. There's systemic and institutional mechanisms that allow for this, not just how juries show up, how a juror shows up and is removed during the process known as voir dire, but through the way we summon our jurors, whether or not someone has a license or they're registered to vote or they live in a neighborhood where maybe they have great public transit, they don't need a license. So how we actually summon our jurors allow for disparities as well. So then there's this idea of prosecutorial discretion. This is probably the most important point in getting into this plea bargaining aspect. The best way to explain this to you is to just show you a penal code we have here in California, and that's Penal Code 487. It's the penal code for grand theft. And what it says is if you're caught stealing something worth $400 or more, you may be charged with a misdemeanor or a felony. That may is the key cursor that allows a prosecutor to say, okay, well, I'm going to charge you with a misdemeanor or a felony. How do they do that, right? Well, it's important to note that the may could be a good thing because it could allow a prosecutor to look at the context of the crime, the person, their history, and kind of decide where they're going there. But what we see most often is that a prosecutor is more likely to offer a defendant of color a felony with a higher conviction than a misdemeanor with a lower one. And why does this happen, right? So you can see the felony 1 is up to 16 months in jail, a felony 2 is 2 to 3 years, and a misdemeanor is a year. Prosecutors are praised on their convictions. They need convictions, a certain number of them, and the longer the conviction, the better, right? To use the court's resources effectively, they're going to bargain in a way initially to where they're not going to receive much pushback. If they are going to go after every person and offer this 2 to 3 years, let's say a white man with a really expensive private defense attorney, they know they're going to be back at that table renegotiating, wasting time and money of the court's resources. So we can see how this prosecutorial discretion makes an unequal scale of bargaining power. So I put up this tug-of-war thing because that's really what it is. It's who has the power to pull someone into a longer sentence or not, who has the power to push back. And I put this quote here, I'm going to read it to you. Bargaining power is the power to take away freedom, destroy livelihoods, and tear families apart. Ultimately, it's the power to devastate low-income communities already suffering from aggressive and discriminatory law enforcement tactics. So by Barcheta and Fontier, what they're saying here is these systemic issues, these institutional things that we already have, they're talking about enforcement tactics, allow for this discursivity between attorneys to weaken the bargaining power of certain people, and then that affects certain communities more than others. So where are the racial disparities in plea bargaining? It's actually really hard to look at it on a countrywide scale because our criminal justice system, even though we're one of the most advanced countries in the world, is not digitized. It is in a way, but not in a way where you could look up certain cases on a mass data level. So Carlos Verdejo did a study in a county in Wisconsin, and what he identified is that the greater disparities are actually in the lower level misdemeanor and felony crimes. There are still disparities when looking at crimes like murder and aggravated assault, but it's actually more concerning that it's in these lower level crimes because these are the most crimes that go before the court fit these. So he looked at the number of charges and found that there was a 25% disparity between black and white men, meaning when controlling for crime, criminal history, and the charges offered in the plea bargain, it's more likely a prosecutor would offer the plea bargain with less charges to a white man than a black man. The more concerning statistic is in the level of charge and severity of punishment, where he found a 70% disparity, meaning 70% of the time, the prosecutor was more likely to offer a black man a felony 1 versus a misdemeanor when they had the discretion. We're talking about severity of punishment. This goes hand in hand here, and I'll explain it just quickly. Severity of punishment is not just the length of a sentence. It's how you're serving that sentence. Is it in a maximum security prison where solitary confinement is basically how you serve out your time? Is it a minimum security prison? Are you serving it in a county jail? Are you doing community service? So the severity goes along with these punishments. So as an anthropologist, it's important to note these top-down approaches, but what I really wanted to look at is what the bottom up is. How do defendants experience this process? And when looking at cases of people involved in plea bargaining, the first thing most people kind of annotate towards is the bargaining power aspect. But then you might be like, okay, Mona, well, these people are criminals. They're agreeing to these crimes they're committed. They're saying, I'm guilty, and receiving a punishment within the parameters of the law. And while there's racial disparities in that, it's technically legal, right? So then we have to look at, because 95% of our cases are done this way, it's basically procedure at this point. How does that affect an innocent person? And is innocence even relevant for some people? And also, what if you just want to refuse a plea bargain? You want to stand up to the system and say, no, I'm not going to take this plea bargain, and I'm going to go to trial. So the fact of the matter is, people do plead guilty to crimes they do not commit. The Innocence Project, if you guys may know it, is a project that works to exonerate people based on scientific data. They found that so many people pled guilty through plea bargains to crimes they didn't commit. They opened a new branch, a new organization called the Guilty Plea Problem that looks at these cases specifically. And what they found is that 18% of people that have pled guilty to crimes thus far, 18% of people that have been exonerated through scientific evidence thus far have pled guilty to crimes they didn't commit. 65% of those people are people of color. This is a concerning statistic, but what's more concerning is this project works on scientific evidence. Scientific evidence is usually looked at for higher level crimes like murder and rape, but these low level misdemeanors are what most people are experiencing, where the greatest disparities are, and it's harder to exonerate people through that process. So now that we kind of wrap our heads around this innocence issue, what about if you're going to be that valorous person and say, I'm not taking a plea bargain, I want to go to trial? I'm going to tell you a story in a moment about a young man. It's a true story, and I'm telling you the story because you guys can go home and look at the Netflix documentary and really break it down. But I chose this for that reason and because it really exemplifies all of the issues that can lead up to the most heinous consequence. And that's the story of Khalif Browder. Khalif Browder was a 16-year-old teenager when he was walking home from a party in the Bronx. He was stopped by police officers accused of stealing a backpack. We have to look at that stop first and realize this was a time during stop and frisk in New York, which we know now disproportionately affected communities of color. He was arrested in May 2010. He was in jail in pre-trial detention in Rikers Island for 3 years before he was released acquitted of all charges. But during those 3 years, he was offered a plea bargain 15 different times. He showed up in court 30 different times. Also during those 3 years, he was placed in solitary confinement in Rikers Island, and when you add up the time together, it was for more than 2 years. After his release, Browder was looked at as valorous. He appeared on shows like The View, made friends with Rosie O'Donnell. Everybody talked about him like a hero who stood up to the system. But due to his dilapidated mental illness, likely from solitary confinement, Khalif Browder committed suicide. Now I see your faces, and this is a heart-wrenching story. But what's important to note is the story is actually not alone. While the ending may have caught media attention, and there's been reactions in New York to end certain practices like these, there are systemic issues that allow for this to happen every single day. Khalif Browder was on a pretrial detention status. Of the millions of people in our adult supervision facilities right now, over 30% of them are also on pretrial status, meaning they're yet to either accept a plea bargain or be convicted of a crime in trial. So to tie this all together, as anthropologists, we should be concerned about this. It's an important arena for anthropology and the law to cross-fertilize. Second, when we think about reforming our criminal justice system, cases like this come up. What we think about is policing. We think about the models that allow for certain communities to have hotspot policing or stop and frisk. We also think about how do we rehabilitate people more effectively, but what I'm arguing here is we should definitely think more about plea bargaining. And I'm going to leave you with a quote from Justice Anthony Kennedy, who said, in today's criminal justice system, the negotiation of a plea bargain is almost always the critical point for a defendant. It's not some adjunct to the criminal justice system. It is the criminal justice system. So with that, I thank you all for your attention. I know that was a lot of information. I don't know what happened to my slide. And I'll take any questions you may have.
I was wondering if you could speak a little bit more to how juries are an issue with this particular topic.
Okay, yeah, definitely. So first, it's important to note that back in the common law era, juries were not necessarily juries that were, right now we refer to them as juries of your peers, but as we all know, you cannot know anybody that's in the defendant's chair. So if you look at the history, we can see that juries were actually people's peers. And they were less likely to find someone guilty of a crime that's gonna, send them to the guillotine if they knew them. They would take context into account. But as we speed up this process, we know now that juries are mostly white. And why is that? So at first I thought it was because of a process known as voir dire, which I kind of talked about, but that's basically where attorneys and prosecutors go through a process of eliminating people from the jury. But then when I looked deeper, I found an ACLU study that had the same question. And it looked at a county in Alameda County in California. They picked this county in particular because it's one of the most diverse counties in the country, and it's in California, which is kind of regarded as progressive on criminal justice reform. What they thought is a more diverse county would have a more diverse jury, and what they found is that's actually not the case. And it's not the case because of these systemic processes through summoning jurors. So if you're summoning a jury based on who's likely to have a license or who's registered to vote, there's disparities within that. But if you think of the case of Khalif Browder, right, he's from the Bronx. So in the Bronx and in a lot of the inner cities in America, public transit is what people rely on, so they don't need to have a license. And we also know that voter turnout there is not the best. So it's not just about eliminating people from the jury. It's about how we get them there. And then once they are there, in voir dire, you can remove people on the basis that they may be biased. While you're not allowed to say, I'm removing you because you're going to be biased because of your race, what attorneys have noted is you can remove people by saying, I don't want this person on the jury because they live in a neighborhood where it's heavily policed, or their brother was convicted of a felony. Therefore, they're going to be biased against law enforcement. So we can see how these racial disparities come out of that. Does that answer your question?
I think I remember you said you're planning to go to law school?
Yes.
Yes. So I'm just curious, as a lawyer, or I don't know if that's your ultimate goal, what could you do to help reduce this disparity?
And that's the million-dollar question,
Yeah,
right?
right.
So when you look at this, part of it, like I said, you would think that because lawyers know about this, right? This disparity is not news to most people, that there would be some way they can equalize the outcome through their discourse. And what I'd be naive to offer solutions today, but I think some things we could look at is how prosecutors are praised for convictions. We can also look at how we summon people to juries, and we can also look at public defenders and what their resource is like as far as getting into the courtroom. I also think that in terms of pretrial detention, we should not be holding people in pretrial detention unless they are actually a violent criminal, let alone putting them in solitary confinement. And I also think when we really break this down, there's so many factors to look at that judges should have more of a role to play in this rather than just like allowing prosecutors to go about this. But this is all heavily weighted on how can we get these resources. So I hope that answers your question in a way, but definitely more research is needed to look at that.
So, isn't also the problem lies in the fact that in higher education there's like disproportional in race as well, so like even
Right.
prosecutors are going to give specific race that have specific bias against specific group of people, so that when trying to prosecute them, it's highly likely they will prosecute a black man with a higher crime than it is with a
Right.
person that they see as a white person. And there has been like a lot of psychological studies where like black people are seen as more violent in general, even at the age of 2 to 3,
Right.
4 years old in kindergarten. So like how do we propose a fix for a system that is already biased against?
Exactly. So I think you touched on a few important things. First, you touched on the idea of a prosecutor and the likeliness of them being a white person over, let's say, a black person. And that would tie into all of these systemic issues that I looked at, right? So like how do we get this disparity to equalize throughout many processes, not just plea bargaining? And we have to look at how we educate people about race in this country and when that starts and how we allow things to happen within our sociocultural mechanisms. But I also think that it's a much larger solution than anyone could offer by themselves, and it's going to require a lot of people at the table, specifically people of color, to look at it. What I will say, though, is even in cases where the prosecutor is black, and in the Khalif Browder case, both the DA and the prosecutor was black, we don't see things going easier, which is very concerning as well. So I hope that semi-answers your question. Yes?
I have a kind of very related question. So you said this is an issue that we as anthropologists should be interested in.
Right.
Well, obviously we should be interested in as citizens, just as human beings. But I'm interested in the perspective that you might bring as someone going to law school about trained in anthropology. So what can anthropology, or what's the central contribution that you think an anthropological perspective on this issue brings
Right.
to?
So I think most other disciplines, in a large sense, are concerned with these top-down approaches I talked about, right? So double major in political science, so there's some history majors in here. We look at things top-down, and then we try to assess them from the bottom up. And I think that as anthropologists, the more we can look at cases like Khalif Browder and publish ethnographies on this and get people to understand what happens, in particular to educate law students and the legal realm in a sense that these actions have effects on people, and being less concerned with patting someone on the back for getting a conviction than understanding this whole mechanism. So I think, I know there's courses here on gender and incarceration and other issues along those lines. So I would definitely say that as anthropologists, we can look more in our own backyard and in our own systems rather than continually reaching across the world and looking at tribal societies and how they do things, although that's important. And I also think it's just another perspective that can connect this institutional legal thing we all kind of respect naturally, that we're taught to respect these institutions, hierarchies, and as anthropologists we can kind of illuminate where those are broken down. Okay, yes. Thank you.
Thank you.
All right, let's see if the technology works this time. Okay, so today I am going to be talking about dung burning at Harappa, the origins of weed seeds, or weeds, in the archaeological record, 3300 to 1700 BC. So looking at this title, there might be a few things that you are unfamiliar with. For example, what is Harappa? Another thing is weeds, why do we care? And then why does this matter, how they got there in the archaeological record? So I'm going to be going into all of this, so just please bear with me initially, as there is going to be some background, some explanation, which will then lead into what exactly I am analyzing today. So just some context. Harappa is actually an archaeological site in modern-day Pakistan. It's in the central Punjab region today. Historically, or rather, you can get nitpicky with the historical, depending on who you want to ask, whether there's writing or not. But you can conceptualize Harappa as a city. It went through different periods of size and social organization. So we have moving from 3300 all the way to 1700. These are just major periods of occupation and how that changes through time. All in all, it was occupied for around 4,000 years. So what is it that I'm looking at today? As you can see here, there is this lovely little charred seed. So excavations at Harappa, all the way from 1986 all the way to 2001, have unearthed large numbers of these charred weed seeds along domesticated crops. So what I'm interested in looking at is how on earth did they get into the archaeological record? What process was responsible for depositing them in the archaeological record at Harappa? Now, in this region of study, archaeologists have two main theories going for how weed seeds particularly get deposited in the archaeological record. The first is crop processing, and the second is dung burning. And dung burning is kind of what I'm going to be emphasizing today and investigating today through the use of flowering time. But again, I'll get more into what exactly that is a little bit later. So you might be wondering now, why do we care about the deposition of weed seeds, that process, and why do we care about it in the context of Harappa? So from understanding how weed seeds get into the archaeological record, you can actually infer increasing social complexity and climactic changes, as well as human responses to climactic changes. Now, Harappa was occupied throughout that 4,000-year history. They did face major climactic changes during that time, and they also had increasing and decreasing social complexity at a pretty significant scale. You had, at its peak, 40,000 people. You could argue about that, it's an estimate, all the way to more in the lower thousands. So that's a pretty significant difference. So understanding how the weed seeds got into the archaeological record at Harappa, we can learn more about how the first cities were formed, and also about climate change and how humans respond to those climate changes. And we can apply that knowledge to today. So moving a little bit backward, what exactly is crop processing? So crop processing is just the series of steps undertaken by humans, all the way from harvesting and then cleaning the grain. So you can't just go out into the field, scoop it up, and then pop it into your mouth. There's a series of steps that you have to take to remove different parts of the plant. When you're eating actually grain, barley, wheat, etc., you're actually only eating the weed seed. That's what flour is typically made out of. But there's a bunch of other things that come along with harvesting. Additionally, there are weeds that grow alongside the crops. So if anyone in the audience is a gardener, you know that weeds are a problem. You have to rip them out, etc., etc. But when you're harvesting them, you just kind of harvest everything. So you have to go through a series of filtration steps, and it's actually these filtration steps that produces debris, and in that debris are these weed seeds. That debris is then burned because it's trash, and that is the process by which you get weed seeds in the archaeological record through crop processing. The next process is dung burning. It's exactly what it sounds like. People are going out and they're collecting dung from animals and then burning it as fuel. So this ties into weed seeds because these animals are being led to pasture, so they're just being led to graze, or they're being given food by people. And some of this food includes the weeds that are just growing naturally in the region, as well as whatever people are growing to feed these animals. And then this dung is burned as fuel. So why is it that I'm looking at dung burning as opposed to crop processing? Well, the assemblage at Harappa has yielded some interesting results that don't necessarily conform to the patterns of debris composition that archaeologists would expect with crop processing. So the first is very few rachis remains. This is just a particular part of the plant which attaches the seed to the actual stem. So if you have very few of these, this indicates that the crop assemblage has been cleaned. It's very processed. But you also have the abundance of these small weed seeds in the archaeological assemblage at Harappa, and this indicates a very unclean assemblage. So you have this contradiction between a clean assemblage and a not clean assemblage. So what is the alternative explanation for deposition of weed seeds? Dung burning. So how exactly am I evaluating dung burning at Harappa? And that's through the use of flowering time. As you can see through this very, very pretty picture that I won't talk about hardly at all, the plant goes through a life cycle, and during this life cycle, it flowers. So flowering time is actually very contingent on the environmental factors. So that could be soil aridity or water availability. So if you have plants that are all growing in the same region, they will probably flower at the same time. So the way that ties in with weeds is if these weeds are growing alongside these crops, their flowering time should be approximately the same as these crops at Harappa. And then again, as I explained, through crop processing, that's how they get deposited. So if it is crop processing, these weed seeds should be flowering at approximately the same time as these cereal crops, grain crops, etc. Something that's important to note about Harappa particularly is that it has two major growing seasons. That's the Rabi, which is the winter, and the Kharif, which is the summer. The Rabi is actually where you have the majority of your crops growing. So, expanding on this hypothesis, if the majority of weed flowering time co-occurs with the winter flowering time, then likely these weeds entered the archaeological record through crop processing. So that's exactly what I'm measuring. That's what I'm testing today. So just for a visual representation, the winter flowering months are February, March, April, and May. So this is the distribution of flowering time or weed flowering time that you want to see or you would expect to see. And this is what I actually got when I ran the most numerous weed species. So this is exactly what we found at Harappa and then identified, we being the lab. But this is the actual distribution. So as you can see, it doesn't only flower in the wintertime. You have the majority actually flowering at the summer, but you still have a lot flowering at the winter. So that poses the question, how exactly do we interpret this? This does not conform to the hypothesis that I have devised. So in considering what affects flowering time, we look back to the ethnographic record. So animal feeding strategies can actually have a big impact on flowering time because it changes where you're getting the weed seeds coming from. You could also be getting it from grazing, so this would be the wild weeds, and you could get it from foddering. Now, foddering crops in the central Punjab is kind of interesting because people are actually growing their foddering crops alongside their winter crops. So depending on if people are feeding their animals these foddering crops, the flowering time might actually tend towards the winter as well. So it won't necessarily be crop processing, but it could also be dung burning as well. So that kind of confounds the hypothesis, but don't worry, we'll get to a little bit more explanation of that. So the way that we kind of determine which is which is by looking at the actual plants that we find in the assemblage. So I'm calling them weeds, but we don't actually know for sure if they are weeds. We can kind of answer that question by looking at the ethnobotanical record. So for example, Medicago is one of the most numerous weeds that we find at Harappa, but in the ethnobotanical record, it's actually a foddering crop. Trianthema triquetra, which is another common weed in the assemblage, is in fact a weed in modern-day Punjab. Chenopodium actually might be modern, so that effect on flowering time might be debatable, because we might not actually have to include it in the assemblage at all. And then you have Saperaceae and Poaceae, but these are actually entire families. They encompass hundreds of species, so unless we refine the IDs, we're not going to be able to really place them. So where does this leave us in the question of evaluating dung burning at Harappa? So to remind you again, this is what we expected if it was crop processing, and this is what we got. So based on the ethnobotanical record, the consideration of what these seeds are actually in the ethnobotanical record, I'm putting forth that it's not just crop processing that is responsible for the deposition of these weed seeds at Harappa. That's what's been argued predominantly in the literature, so at least now we can throw that out. But whether we can say, it's true, someone's going to fight me later. But anyway, so it could possibly be that they are foddering as well as grazing their animals. And given that you do have this almost evenly split distribution, that's personally what I think of right now, but that actually might be subject to change. And let me tell you why. So as I mentioned before, we need to refine the identifications for Saperaceae and Poaceae. And we also have to take into account the number of seeds per plant. So certain plants might produce 20,000 seeds, where one plant might produce 5. So depending on what counts you have in the archaeological record, the way that that distribution was calculated was based on the raw counts. So by taking into account the number of seeds per plant, that distribution might change and you might get a different pattern. So overall, again, crop processing is probably not the only process responsible for the deposition of weed seeds in the archaeological record. There is definitely support for dung burning. It might be foddering, it might be grazing. More research will be able to tell. But before I let you go, and before this stops working, I'd just like to remind everyone about archaeology and why we're even bothering. Yes, we learn from the past, but also remember, the present will someday be the long past. This was 4,000 years ago, and this was someone's reality 4,000 years ago. We're looking at their trash today. So I just want to pose the question, what legacy will we leave behind today? A lot of what we produce in terms of trash is going to be here for about 500 years. This is 4,000 years. What is it about our trash that will inform future generations about how society works, how processes work, how people live, and how to deal with the challenges that their future or their present will face? So I'd like to thank my advisors, Jade. I know you have your new baby, so. I'd also like to thank all the archaeology graduate students over at Washington State University, and particularly at UCSD. Some other faculty members as well for supporting me through this research project, helping me get funding for different things so I could continue this research. I'd like to thank the honors cohort, and then family and friends, and then miscellaneous people who I might be forgetting. Thank you. I would be happy to take any questions.
The plants that you list have different ecological requirements.
Mhm.
So the fact that cypress is a wetland plant,
Mhm.
would that not, how, did you look at distribution rainfall or different kinds of environmental constraints that would have been on the different plants that could explain the distribution that you ended up finding?
Yes, so that kind of relates to the actual physical geography of the site. I didn't show a picture of it, but Harappa is located very close to a river. So it's likely, and that also ties into water management strategies, and again, the geography of the actual site. So yes, Saperaceae could have an effect because it's growing near the river. But what is important to note about Harappa specifically is that it's in a very, very arid location. So it's actually not enough to support like wheat, barley, agriculture by itself. So people are actually using water management strategies. So in terms of looking at what has the drier effects or what is growing in a drier area, it's going to be pretty standard across the area, aside from what people are particularly growing or what would be growing by the river. So in answering that question, assuming that it's pretty much the same over that small area, except by the river, which again will be determined as how people are feeding their animals. There are instances, depending on what animal you have, what you're feeding it. So for example, there's water buffalo and cattle at the site. Water buffalo do go, and they might be grazing, where there might be Saperaceae as well, which is, again, determined more by wetter conditions. So that does play a role in it. Another thing that we did to take into account that kind of distribution is looking at the flowering time of modern foddering crops and grazing crops. And that was a very similar distribution, and you have about a 50-50 split. So it's not perfect in terms of taking into account those factors. And you could also go into like, how do you know about the local regional climate throughout those 4,000 years? You can't actually know that because it is archaeology and there isn't that exact science. So in the nature of archaeology, you have to take everything with a grain of salt, but it is taken into account to a certain effect based on geography, what people are feeding, and also looking at the ethnobotanical record. Does that answer your question? Okay. Other questions? Yeah. All right, I think that's it.
Great job, you guys. Very proud of you. All right. So this brings us to the awards part of today's meeting and ceremony. And I would like to start by saying that we have a lot of exceptional students to acknowledge. And I would like to start with the tradition we have in our department to give our 4 departmental awards. And those are as follows. I will start with the Washburn Award for Excellence in Biological Anthropology. And what you have up there is the winners of the award in past years. And this year's award goes to Alexandra Gofford. You're welcome. Congratulations, Ali. Our next award is the McAdams Award for Excellence in Anthropological Archaeology. And this year's award goes to both Isabel Villasana and Sarah Rabel. So if you guys can come up here. Congratulations, Isabel. Good job. Congratulations, Sarah. The Hallowell Award for Excellence in Sociocultural Anthropology this year goes to Galen Walsh. Galen graduated already in the winter quarter, and she cannot be here with us, but she should come and pick up her award from the department. The Mel Spire Award for Excellence in Psychological and Medical Anthropology this year goes to Carolina Oseguera. Congratulations.
Thank you so much.
Okay, and we have an excellent group of honor students this year, and we would like to acknowledge all of them. And there is a special cord and achievement framed award. The cord is something that previous colleagues of yours had designed in the past. It has 3 colors that are intermingled, white, green, and yellow. So, and this is a tradition that we keep having. We keep these cords out to each year's honors group. So I'm going to start alphabetically with Mona Abud. Thank you. And Alyssa Brumley. Clara Dawson. Congratulations. Adriana Ferguson. And Isabel Gonzalez. You cannot see the name, it's white, but it's going to show up. All right. Carolina Seguera. I did. Congratulations again. And I skipped someone? I skipped Ali. Yeah? Alexandra Gofford. Yes. Ali, please come over. Your card. Somebody wants to do it.
Thank you.
And Sarah Rebels. Again, congratulations.
Thank you. One more hug.
One more hug. And we know that we're not going to use white again on the board because I can barely see this. So Isabel Villasana. And Galen Welch, who is not here today, but congratulations to her as well. Okay. We have another group of people who over the years have helped the department with a lot of outreach activities, and you have pictures from previous years. And I would like to acknowledge our ambassadors of anthropology. And this year, our ambassadors are Mona, Adriana, and Isabel. So thank you for everything you've done. We have our anthropology club. We have all the people involved in our club. So congrats to them again. Thank you. And then, of course, we have all of those people who helped with our undergraduates throughout the year, and this includes a lot of different groups of people. I would like to acknowledge our lecturers in anthropology, all the PhDs who are teaching several of our classes, and you have a long list of people here on the board, so thank you. The many, many graduate students and associate inns who educate our colleagues and our students along with the regular faculty, a long list of them, so thank you. And our graduate students in the mentor-protege program who help interact with our undergraduates and mentor them, so thank you very much. I would like to acknowledge and all of the alumni who stay in touch with us over the years, and I would like to please ask you to stay in touch and to communicate to us your successes over time. And then, of course, we need to acknowledge our staff, especially Garrett, who has been so helpful this year as an undergraduate advisor, everyone in our faculty across the different majors, our staff in the department. I would like to also add a special thanks to our librarian, Sarah Kalubucha, who has been such an amazing force in really always be present to help with the preparation of the honor students and always make herself available to assist and come to our classes and be there. So thank you very much, Sarah. So I have been serving the department as the vice chair of undergraduate education for 7 years now. I wasn't sure when I was given the job if that was going to really be the best fit for me. It turned out to be an amazing experience. I'm grateful for being given this opportunity to work with the students. But now it's time for me to step down, and I'm passing the torch to my colleague, Professor Amy Non, and I wish her best of luck starting after the end of this academic year. So welcome aboard, Amy. At this point, I would like to ask everyone to join us for a little reception to celebrate our students' achievements. And again, thank you everyone for coming here today and for your attention. Thank you.